FLSA Overtime Rule Changes, Preparing for Compliance, was a live webinar that was originally produced on Tuesday, August 30th, 2016. The presenters for this presentation were Suzanne Sentman with McConley and Asbury and John Martin with Rhodes and Sinan. Enjoy this webinar recap and visit us online at www.macpas.com for more information about our future events and presentations.
Thank you, Tyler. Once again, my name is Suzanne Sentman, and I'm the Human Resources Director for McConley and Asbury. In addition to providing human resources support for the folks here at McConley, we also try to provide our clients with up-to-date information and things that they can do immediately within their workplaces. As many of you have heard, the Department of Labor released its final rule this May 18th, revising the overtime exemption regulations of the Fair Labor Standards Act and making as many as 4.2 million employees now eligible for overtime pay. Workers classified as exempt but making $47,476 or less will now be eligible for overtime earnings, and this is all effective December 1st. During this webinar today, we hope that you will learn more information. You will understand the final rule and who is affected by it. We'll take a look at compliance options and finally learn what steps we can take now to prepare for implementation in advance of December 1st. So time is ticking. With me today, as Tyler mentioned, we have John Martin from Rhodes and Sinan. As a partner, Mr. Martin's practice focuses on representing employers in all aspects of employment law and litigation, including gender, age, disability, and race discrimination cases, wrongful discharge and breach of contract cases, wage cases, cases under the Family and Medical Leave Act, non-compete and breach of fiduciary duty, injunctive release cases, and unemployment compensation cases. Quite a laundry list. Mr. Martin is a frequent lecturer, giving presentations on a wide range of employment law topics such as social media, wage and hour issues, discrimination, and sexual harassment. And in addition to providing clients with advice regarding employment issues on a day-to-day basis, think of handbook and policy review, questions regarding employee discipline, etc., Mr. Martin trains human resource professionals, supervisors, and employees on a variety of employment-related topics. So I had to bring the big guns in today to help us get through and better understand the final rule to the FLSA and what that means. And I feel confident that John's going to be able to share some great information with us this afternoon.
Well, thank you, Suzanne, and thank you, everybody, for attending. I just want to add two other things. I don't have the on-air radio voice that Tyler does. I really wish I did. That was very impressive. And two, I apologize for the picture that's being used. Mine's going to be updated. I do have a beard now and a lot more crow's feet around my eyes. I had to grow a beard because there was an age discrimination trial I had previously this year, and I needed to grow something so that the jury wouldn't sit there and go, who is this Opie-looking guy?
You mean like Doogie Howser?
Yeah, telling me about age discrimination. So I have somewhat aged a little bit since the use of that picture. So please, your mileage may vary.
Well, thank you again for joining us. So let's go ahead and get started with the presentation. So way back in March of 2014, there was a presidential memorandum issued where President Obama directed the Department of Labor to update the overtime regulations. And John, I don't know what you can comment on with this, but I think this was probably a long time coming, considering the current salary threshold level that was set. But anyways, the whole intent of this was to better reflect the true intent of the FLSA, and then to hopefully simplify and modernize the rules so they're easier for everyone, both workers and employers, to understand and apply.
Yes, and I think what's important to understand is the concept here is we have the FLSA, the Fair Labor Standards Act itself, which was a law that was passed by Congress almost 80, 90 years ago, back in 1938, that relatively and largely speaking has remained unchanged to this day. The life and where this law lives and breathes are in the regulations that are sometimes the dust is blown off them and they're revamped and they're revised every decade or so, and that's done through the Department of Labor, which is a branch of the executive branch of government, and specifically through the Wage and Hour Division of the United States Department of Labor. And so what President Obama did a few years back is said, hey, we really need to update the standards that our employees are working under this particular federal law, and that was incumbent upon the Department of Labor then to look at that. And again, to say that the law itself, the Fair Labor Standards Act, needs to be modernized is somewhat of an understatement. Mm-hmm. Employees are still, if you are subject to the FLSA, you need to be compensated for all time that an employer suffers or permits you to work. So basically, you're paying your employees for all the time spent suffering their work. That's the verbiage and that's the language being used in the law. But more and more in terms of the enforcement priorities of the Department of Labor, of the Wage and Hour Division, what we saw over the years, over the past decade or so, was that the thing that we're going to be talking about is the salary level, which is one of three components. If you think of a three-legged stool, it's one of the legs that is required to meet an exemption status of the FLSA, because essentially what the FLSA says is if you are subject to this law, you have to be paid a minimum wage and you have to be paid overtime for all hours worked over 40. And here are some things that you can do to get yourself away and outside of this law. So you're either subject to the law, which means you are non-exempt, and believe me, I hate these terms because I get tripped up in my own mind sometimes. But if you are non-exempt, you are subject to the law. If you are exempt, you aren't subject to the law. But what we came to find is that the low salary threshold basis, or the threshold level, was $23,000-ish, and when there would be an audit or an investigation being conducted by the Department of Labor, and they do come a knocking, what they will do is they'll look at what that individual is being paid, and if that individual is being paid somewhere in the mid-20,000 range or even in the 30,000 range, the investigator is going to look very closely at that position, because just on a general smell test, what the Department of Labor came to essentially find as an unwritten rule was that very likely that position is not going to be considered exempt from the overtime requirements. So really where we are today is more of a codification of what we already kind of knew. You need to be in that mid to upper 40,000 range before the Department of Labor is going to start saying, you know what, that's likely an exempt position. So I think with that background and that understanding, it's going to be helpful as we move forward and talk about the changes.
So looking at the next slide then, as John mentioned, this and an interesting fact I have to say when I read about this, so the FLSA was really an outgrowth of what was happening economically in this country as a result of the Great Depression. So you had folks taking jobs under any conditions, any hours, putting themselves in harm's way, and fair enough, I think it's fair to say the government was trying to do something to benefit the workers, the American worker out there. So I just thought that was an interesting fact as to where this all, when you said about the suffering.
Oh, yeah, no, yeah, and this certainly
that
came out of...
That verbiage kind of, it makes sense at the time when you think about it, where this was all kind of coming out of. But as John mentioned, so it does guarantee a minimum wage for all hours worked. It does limit the number of hours an employee can work without additional compensation, and that's 40 hours per week. And looking at this, you might have a pay period where you're looking at, I guess, the amount of hours that you're paying on that paycheck. But keep in mind, the FLSA, you cannot average hours. You can't look at the total amount of hours in that pay period. It has to be, how many hours in whatever your pay week has been set up to be.
Correct. There's a statutory work week of 7 days. And so when we talk about overtime, when we talk about 40 hours, we're only looking at that particular period of time. Employers certainly can pay employees on a biweekly basis, on a semi-monthly basis, and have more than one work week in a particular pay period. However, when we're talking about purposes of overtime compensation, we're looking at each individual work week. So if you have an employee who worked 35 hours one week and 45 hours the second week, it's not a wash. There's 5 hours of overtime that needs to be compensated in that second week, regardless of what number of hours they worked in that other week.
And just kind of to piggyback on what John was saying earlier, so if you are exempt from minimum wage and overtime pay protections, that means that you are in a bona fide executive, administrative, or professional capacity, or EAP classification. There are other classifications out there. We'll talk a little bit about that. And again, this comes off the, I believe, the Department of Labor's belief that workers in those classifications typically have higher salaries, well above minimum wage. They, enjoy other fringe benefits, maybe even have better job security, so they're not in need of, the overtime protection.
And the mnemonic that I use in my mind a lot of times when I'm differentiating between exempt employees and non-exempt employees is that non-exempt employees are paid for their time. Exempt employees are paid for the job that's being performed.
The results.
Correct. Mm-hmm. And before moving on, I just a few another points that I wanted to raise about the FLSA and the fact that this is an issue, and we certainly have a nice turnout talking about this particular subject. I've fielded questions from a number of clients in the recent months where they will say to me, Is this really a real thing? Is this something that is really going to be enforced? Do we really need to do this? And invariably, my answer is always a resounding yes, because in the past handful of years, the funding that has been funneled to the Department of Labor specifically for purposes of investigation, looking at misclassification, conducting audits of employers, and believe me, the Department of Labor will field complaints from employees who feel as though that they're not being paid sufficiently, and they will just independently and randomly show up and start knocking on doors and say, can we please see your pay records? And when the federal government asks, you say, how high? And there is an app that the Department of Labor has put out that people can have on their Android or Apple devices, which allows them to track their time and then send it in and email it to whoever would be interested in seeing that. The Department of Labor is incredibly active. And this is a law that has teeth. Over 9,000 or nearly 9,000 FLSA lawsuits were filed in 2015. The vast majority of those were what were referred to as collective actions, where you don't just have one employee saying you didn't pay me overtime or you misclassified me and I am owed this additional amount in compensation, but these 100 other employees are joining this lawsuit with me. And oh, by the way, I'm entitled to liquidated damages, meaning I get double my compensation, and you have to pay this bloodthirsty attorney over here who is the man behind the curtain pulling all the strings. So this is a law that has teeth. So when somebody asks me, is this something that we really have to do, without hesitation, the answer to that is yes.
And I don't want to get ahead of ourselves here, but you just made me think of this. For employers who are looking to make changes January 1st, because interestingly, this is effective the last month of 2016, correct? So from a budget standpoint, if you're making changes effective January 1, maybe a question could be, hey, can't we just, wait until January 1st when we do make some changes to folks' compensation levels or such? And what would you respond? I mean, I'm looking at your head shaking right now. But
you could. You could. And so long as those changes were made within 1 month anyway, I think that window of damage is fairly small. Mm-hmm. And so that's something that would be easy to pick off. But you would just have to weigh that against, the administrative headache of trying to hurry up and get everything done by December 1st, or if you can wait to do it, at the 1st of January to come into full compliance. But I'm not sure if, hey, we got there as quickly as we can or as we could is going to be a viable defense to the extent that you do have an employee who wants to come forward and bring a claim, because they would obviously be entitled to the wages that they didn't receive in December, plus liquidated damages most likely, because everybody is fairly aware of the change in this regulation right now, plus the attorney's fees that would be associated with that, and any corresponding state law claim that they could tack on to that as well. So I can't see a situation where an employer could say the procedural and administrative burdens are going to be so cost prohibitive as that we can't put this in place by December 1st.
Okay. All right. So looking at the next slide here, as John hinted at, there is a 3-part test to determining if an employee meets that white-collar exemption. The salary basis test what he said earlier, you're paying someone for their results, for the work that they do. You're not reducing their pay on a weekly basis because of variations in the quality or how much work they actually get done. The salary level test, the amount has to meet a specific amount, and that's essentially what we're talking about today. And then the duties test. Job duties must involve executive, administrative, or professional work. And more information, I mean, if you go out to the DOL website, you can certainly, if you're not familiar with those classifications, you can certainly look at that duties test. But the salary level test, like we said, that is what we're focusing on for purposes of this conversation. And the DOL has long agreed that the salary level test is really the single best test of exempt status for white-collar employees. Because once again, these are folks that are usually paid at a higher level. They enjoy perks, fringe benefits, etc. And where I guess kind of the wheels fell off, as maybe maybe you have read about this, but if you leave that, it used to be 23 and some change, if you leave it at that same level, it diminishes over time with inflation, and it just doesn't hold the value of saying, yes, you're exempt and you're at least making $23,000.
And the fact that now again, it's more surprising that we have had a salary level that has increased to the extent it has under this new rule. That's somewhat of a surprise. But the fact that the regulations themselves were revisited after 12 years is not surprising at all. On average, it was about every 8 to 9 years when these when these issues were revisited by the Department of Labor. So the time had come. The fact that they have essentially sent shockwaves through the employment community by the substantial amount of the increase is one thing, but the fact that we're talking about an increase is not in and of itself something that is
surprising or
correct. In terms of, and just to kind of go look at the that number, as I had mentioned previously, $23,660, $25,000, that mid-range, that was a dog whistle really for the Department of Labor and their investigators at the Wage and Hour, and for a reason where they would say, very likely that individual isn't really meeting that third prong, that duties test. If they truly were doing executive functions, administrative functions, or professional functions, they would be paid accordingly to whatever standards that the investigator had in their mind, where they felt that a salary that low, comparatively speaking, to what would be needed to meet the particular duties of that third leg, it just didn't even out a lot of the time in the investigator's mind. Now, executive functions are basically the manager. That's the boss. That's not the assistant manager. That is the manager. That is the person who has the right to hire and fire. That is the person who is overseeing 2 or more people. Administrative functions are non-manual office work, where somebody has that independent and they're able to exercise discretion on matters of significance in the workplace. And professional employees are those with higher degrees and experienced learning of, and I have the language here, and I always get tripped up on that. In a field of science or learning, advanced degrees, and things like that. So if you have somebody who meets those qualifications, but as an employer you're saying, yes, but we pay that person $24,000 a year, it's sometimes, as I said earlier, the Department of Labor would say that doesn't really pass our smell test. Now, under the regulations, it certainly could, but what we were seeing have happen was that they were coming down a lot harder on the duties test to overcome and overcompensate for the fact that they felt that salary was too low. With the salary level being risen now, I think we're going to see, hopefully, a softening of an increased focus on the duties test, and that's just my expectation. Don't take that to the bank one way or the other. Don't cite John Martin as a source on that. But I'm hoping that once they feel that the salary level is more in line, we are not going to have to be pulling our hair out all the time, focused on, well, does this meet that particular duty? I think there's going to be a little bit more of a pass, hopefully.
Interesting. So, as we mentioned, this is all coming down the pike December 1st, and 4.2 million are estimated to benefit from this. folks earning less than $47,476, that translates to $913 per week, will have to be paid overtime, even if they do meet that exemption, that EAP exemption that John described. Interestingly, the DOL will increase this threshold every 3 years. So the first update is slated for 2020, and most likely it is going to be at $51,000.
Yeah, and really, I think the most surprising thing that has come out of these final regulations is when the preliminary or the draft regulations were circulated for comment, it was over $50,000. Excuse me. And the Department of Labor had said, and we're going to revisit this and increase this every single year. And as you may imagine, pretty much the collective management side of the United States lost their minds and said, how do you and expect us to continually revisit and revise these numbers on an annual basis, and that is way too high. The Department of Labor took that to heart, and they came back and they said, okay, we're going to peg this at the 40th percentile of salaried employees in the lowest wage census region of the United States, and right now that is in the South. So at the 40th percentile in the southern region of the United States, salaried employees are making $47,476. And then the Department of Labor said, and we will revisit this not annually, but we will look at this every 3 years, and we will use the same benchmark. Now, the Department of Labor is saying we anticipate in 3 years that that number is going to rise to $51,000. That's all well and good. That's all speculation at this point. My concern is not the $47,476 number that we're working with right now. My concern is what that number is going to be on January 1st, 2020. The Department of Labor anticipates that a lot of these employees, these 4.2 million employees, a lot of these employees are simply going to be converted to hourly employees. I don't see that being the case. I see a lot of these employees being converted to salary non-exempt, where their overtime hours are still going to need to be taken into consideration, but they're going to be kept on a salary basis. I see a lot of these employees getting a bump in their salary to keep them in that exempt status. And if that's the case, and we have these employees who are still getting the salary and those salaries are increasing 40%, the 40th percentile of that number is not going to be $51,000. It's going to be closer to $60,000 or maybe even higher. So this potentially has the the potential to really run up the run up the meter. But again, we're not going to know until 2020. But it's the law of unintended consequences, and we can look at the Affordable Care Act as an example. And I think the headlines right now are that they were projecting to have 20-some million in the exchange at this point in time, and they have about half of that. So government predictions and government, take them for what they're worth. So if they're saying that it might be 51,000 in 2020, it could be closer to 60. But that's my soapbox.
Interesting. So the next slide. This is just something that I pulled from the SHRM website. I would say for those of you in human resource functions out there, SHRM has a lot of great information to help explain this to folks within your organization. And this was just, I thought, a very helpful infographic for you as far as what is changing. It's moving from 23,660 over to 47,476. And as John just talked about, as far as updating this every 3 years at the very bottom there, and voila, that's slated for January 1st, 2020. So,
and again, that 2020 figure is going to depend largely on how many employees affected by this change are converted to hourly non-exempt employees. And one of the options that we're going to talk about in a future slide here is that even if somebody is considered to be non-exempt, they can still be paid on a salary basis. You can still pay your salaried employees a salary. You just have to make sure that they track their hours and that they're paid for any overtime. But that salary is going to affect the index that's being used to peg these. So it's going to be interesting to see how this all plays out.
So just to make sure that we're all on the same page here, the duties test is not being changed at this point. However, there is something that is worth mentioning when it comes to highly compensated employees. Those folks that are subject to the minimal duties test, that percentage, or I'm sorry, that dollar amount is changing. It is moving to $134,004. But keep in mind that the highly compensated employee exemption is not recognized in Pennsylvania.
Yeah, we have very tricky plaintiffs' lawyers here in Pennsylvania that like to find the wiggle room and the play in the joints between federal and state law. And if an employer wants to put all their eggs in one basket and say, well, this is a highly compensated employee, so they are exempt under the FLSA, the plaintiff's attorney in Pennsylvania is going to say, yes, but they are not exempt under the Pennsylvania Minimum Wage Act, ergo you owe all of these damages. So that's nothing that I ever advise clients to rely on here in Pennsylvania. And really the fact remains, if you have an employee who's making $100,000 to the new threshold level of $134,000, I would hope that they're going to be able to meet one of the EAP duties tests as well and be still paid on that salary basis.
What are some jobs, I mean, just because I don't bump into this a whole lot, but what are some jobs out there that would fall under that?
Honestly, I wouldn't even be able to speak to that.
Really?
In terms of somebody who is not in an administrative capacity or a management capacity or a learned professional or a that professional capacity who would be making this amount of money. Yeah.
I mean, it's just surprising. So, just surprising. One thing to keep in mind, though, looking at that $47,476 amount, you can include non-discretionary bonuses, incentives, and commissions if that is part of the employee's overall compensation package. The key, though, is that you can only count up to 10% of that, and you have to make sure that you're paying that to the employee on a somewhat regular, frequent basis. So an example, as noted on the slide there, think of like production goal bonuses, commissions, maybe if someone's in sales, and you're paying these out on a quarterly or, I don't know, every other pay or every whatever the pay period schedule is. So that those are things you can count towards that $47,476 amount.
Yeah, and I'll have some follow-up comments on our next slide, but it is nice that the Department of Labor built in this flexibility. You don't necessarily have to pay them the $913 every week. You can pay them slightly less so long as you have that catch-up payment on a quarterly basis.
And that does take us nicely into the next slide, because here's an example illustrating what John just described. So if you look at the first quarter in this example, looking at that 10% amount, so they would have to at least be paid $821.70 a week. And then that remaining $91.30 would have to be paid as a non-discretionary bonus, incentive, or commission. So to John's point, there is a catch-up sort of payment allowed. So if at the end of the quarter the employee has not received that amount, the employer does have one additional pay period to pay that employee the lump sum in order to meet that minimum salary test. If the employer, though, chooses not to make that catch-up payment, the employee would then be entitled to any overtime hours worked in that first quarter.
And here's the monkey wrench that I get to throw into this whole equation. I like the flexibility that these catch-up payments provide to employers who may otherwise not be able to, on a consistent basis, pay that $913 a month. So this is a nice concession that's provided to them so long as they do this on a quarterly basis. And let me just couch this in employees who earn a salary. They are paid their salary. If they work 1 hour that week, they have to be paid that salary for that entire week. That's the general understanding of the FLSA. If an employee quits or is terminated halfway through the week, a question has arisen sometimes, well, do we have to pay that employee for the rest of that week as well? And there's a specific regulation that says no. You don't have to pay the start or the end week salary, full salary for an exempt employee. But here we come to this catch-up payment situation. Let's say you as an employer would like to rely on and use this catch-up payment on a quarterly basis as a way of meeting your obligations under the FLSA to ensure that this employee stays exempt. But let's say this employee is either terminated or quits prior to you making that catch-up payment. Is that employee now able to say, well, I was non-exempt for that entire quarter, and by the way, I worked all this overtime and you owe me all of this? I would like to think that they're not going to be able to do that, but I haven't seen specific direction or guidance or regulations from the Department of Labor as it relates to that specific question. So that's an open question and something that I'm kind of kicking around thinking, oh, is that going to be a potential issue? So again, while I like the flexibility of this catch-up payment option, it does not come without its own risk as it relates to the fact that that person is still considered essentially a non-exempt employee unless and until that catch-up payment is received.
Interesting. And then, just one minor point then, if you are factoring in, I guess if that person would be then in turn eligible for overtime, any bonuses must be included in that overtime calculation? Correct,
because really those non-discretionary bonuses that have to be included would be non-discretionary bonuses that did not bring them up to the exempt threshold level.
But
so
they're still there, right?
Yep.
You have to count them.
Yep,
okay.
Absolutely.
So what are some items that you cannot look at in making sure they meet that $913 weekly amount? You cannot consider a discretionary bonus. If there's a bonus that's made at the end of the year, for example, I think of maybe like a holiday bonus of sorts.
A lot of employers right now are saying, well, why can't I just give them a Christmas bonus to cover the entire year, and then everybody still can make that $47,000,
right.
And change, and that's a discretionary bonus. If it's left up to the sole discretion of the employer as to whether to pay it or what amount to pay, it's something that can't be counted toward the wages that would go toward the exempt status.
Any payments that the employer makes on behalf for any medical, disability, or life insurance amounts, contributions to retirement plans, and then other fringe benefits such as maybe there's a match, let's say, into a 401k plan of sorts.
Cold hard cash, that's what we're dealing with here.
And interestingly, a side note, talking about, and I guess this comes up maybe later with compliance, but if you look at that employee's annual salary, or if you make changes to it, or now you're factoring in overtime, wouldn't you say, John, that could also impact benefits that are offered to that employee, like in terms of life insurance benefits? Like if the employer is offering like let's say one times their annual salary.
Yeah.
No, so, it does have ramifications.
There is a butterfly effect ripple that comes from any type of federal top-down law that is imposed on employers to say you need to do this, and there are going to be so many unintended consequences as a result, and that's why I have a job, and I get to
That's why you're here today.
I get to keep my job. That's right.
So this is just one example where, let's say you have someone who is on a fixed salary, they're not paid weekly, or hourly, I should say, they're on this fixed salary. For example, here's someone who works at a college. She's a budget director, not a professor, not teaching. She is very administrative, and she's only making $41,600 rather, or $800 per week. So if she were to go over 40 hours in that given work week, you would have to count that 5 hours as time and a half. And so therefore you would have to take that 41,600, translate that into an hourly amount. That works out to $20 per hour. So now her time and a half for those 5 hours is now $150 of overtime compensation.
Correct. Yeah, and this is where you take each employee, you look at every single one of your employees making less than $47,000 a year. You look at the hours they work, and I would not be surprised if you don't know how many hours they work right now, because you don't have to track how many hours they work. But it certainly would be not a bad idea over the next coming weeks and months to have them kind of log in and see what kind of hours they work. So if you have an employee like Amy here who's making $41,000 and she works about 45 hours a week, is it more economical, is it more cost effective for you to keep her at that same salary level and then just pay the overtime? Or is it more economical and cost effective for you to raise her salary to the threshold level of $47,500 and pay her that, and then not have to worry about her tracking her hours and doing stuff like that? Or do you convert her to an hourly employee and have her punch a clock and keep account of all the hours that she works regardless, and pay her on an hourly basis? There are options available. It's not as though employers are automatically required to increase any of their employees' pay. They can keep that pay the same level. They just need to change the way in which that they're doing it.
So looking at other businesses, industries out there that are affected, we wanted to definitely do a special carve out for our nonprofit groups. Nonprofits are affected two ways with these changes. First of all, there is enterprise coverage, and that means that your organization would not be covered by the FLSA unless you are engaged in ordinary commercial activities that result in sales or business of over $5,000 or more a year.
500.
I'm sorry.
Sorry.
Sorry about that, 500,000. Sorry. So looking at that, for example, churches, I guess you could say a church, strictly, having a parish, congregation, looking at their activities, might they not be making $500,000 per year? Now, if they would have maybe other sorts of businesses, such as maybe a school or a nursing home or a rental hall, I would say that would probably have some implications and could drive that income level up considerably.
I always consider this particular topic a trap for the unwary. For any nonprofit, even if they are working below that threshold in terms of revenue or the sales that they are generating, because while there may not be enterprise basis coverage, very, very, very likely every single employee who works for that institution is going to be covered nonetheless by the FLSA, because the definition of what constitutes interstate commerce is so extraordinarily broad, and if I can bore us all with an old Supreme Court case where this really came to bear, was back in the 30s, again, right around the time that the FLSA was being enacted, and there was a farmer who grew wheat. And what he did is he had his own little bumper crop on the side, and he grew it own for personal consumption, just a small little quadrant that he and his family would eat. And the federal government came in and says, you can't grow that wheat because we need it over here as well. And that case went the whole way up to the Supreme Court, and he said the federal government had no right to tell him what he could do and what he could not do in terms of growing that wheat on his own land. And the Supreme Court said, if you consider what you do in the aggregate, and you grow your own wheat, and somebody else grows their own wheat, and somebody else grows their own wheat, it has a detrimental effect on interstate commerce. So even though he was growing wheat on his own land, that was considered to be something that affected and impacted interstate commerce. So that ship has sailed almost 100 years ago. So I understand for nonprofits, smaller nonprofits, to say that we don't have to do this because we're not covered. Your employees are still subject to the FLSA because by and large they are going to be affecting interstate commerce in one way, shape, or form, making telephone calls, sending emails.
Right.
Anything has a bearing and impact on interstate commerce.
Okay. So like someone in an administrative capacity where they're sitting, maybe they're a receptionist, they're making phone calls, while maybe the organization does not meet that enterprise coverage clause, that person in effect is covered by the FLSA.
If they're not going to get you one way, they're going to get you another way.
So other groups that are affected, looking at educational institutions, there aren't any changes with this rule that provide special relief for groups of higher education. Looking at a teacher, if you have a teacher, they are still exempt from the FLSA at this point.
Yeah, the three special call-outs in this rule, and they had carve-outs for doctors, lawyers, and teachers. Which of these ones is not like the other in terms of their benefit to society at the same time, I might add. But essentially what the Department of Labor is saying, hey, if you have a doctor, you can pay them $30,000 and that's it, and that's completely fine. Or if you have a lawyer, you can pay them $40,000 and that's it, and that's completely fine. If you have a teacher, you can pay them $30,000 a year and that's completely fine. There's no salary level test for doctors, lawyers, or teachers under the new regulations.
And just one thing to underscore here. So as we said on that other slide, if you are in an administrative capacity at both a nonprofit and an educational institution, you are covered under the rule. Going back to Amy, who was the budget director at the college, she is indeed an example of someone who would be covered under the FLSA.
And again, we go back to that test. It's that three-legged stool. You have to pay them on a salary basis, meaning there has to be a fixed amount that's paid to them every week that's not subject to deduction. They have to be paid a particular salary level, which is what we're talking about here today, in terms of that threshold salary amount on an annual basis, and they have to meet a specific duty test, whether that be, and I just like saying duties, whether that be executive, administrative, or professional.
So this begs the question then, John, when you look at churches and other religious entities, looking at the First Amendment, what does this do for this group of folks? Looking further at information that's out there, it makes you think that there could be a ministerial exception to the FLSA, whereas someone who's in a true minister, pastor sort of capacity is indeed exempt from the FLSA, and that points back to the First Amendment.
Correct, and you're right. There is a ministerial exception under the FLSA, as there is under all federal law, which has respect and deference to the First Amendment, religious freedom, and the principles that we are guided by in our country. And it is not anything that you're going to find in any statute. This is judge-made law. This is common law. This is cases where the Department of Labor would bring an action against an employer, and the employer would say, no, 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 we have our First Amendment religious rights to be exempt from this particular regulation or law at issue. Where we have seen this get the most play in courts is through the EEOC and through Title VII claims of discrimination, and whether or not religious institutions can use things that would otherwise be prohibited by another employer or be considered by another employer. And they have come down on the side of these religious institutions to say, we can't step in and tell this church what they can and cannot do. They have that First Amendment religious freedom and liberty to make the decisions as they see fit. Side note, I was on my pastor nominating committee at my church, and they looked at me as the employment lawyer, and they said, well, what can we and what can we not consider when we are, looking at a potential pastor? And I had to kind of laugh a little bit, and I go, we can consider anything we want. We are cloaked by the First Amendment. We can decide that we want to hire somebody who is a white male under 30 if we wanted to. We certainly didn't do that, but we were within our prerogatives and rights to do so based on the First Amendment. That has also bled over to issues under the FLSA. The difficulty becomes it's very much a case-by-case type consideration, and it is very fact-dependent, and there are certain factors that are used and looked at by the court, and the predominant factor that a court would look at is whether or not the person at issue is performing important religious functions within the stated goals of that particular organization. And sitting in a vacuum, I can't tell you if one person is doing that or one person is not. So it really depends on the facts of the case, and it's very factual specific.
So some of the situations that have arisen out of the courts and case law, folks that have been deemed as exempt. There's a list here, but as John said, it's certainly not all-inclusive. You really have to look at the specifics in each situation.
Yeah, and really the reason I say that is because this bullet-pointed list is one judge, one day, looking at one case at some other jurisdiction that is not going to be binding or controlling on another judge in another court in another state in another district. This is very, very much case-by-case, fact-specific. If it gets to this point, all other options have failed.
Right. So shifting gears here, looking at compliance options then. Now that we've reviewed the final rule and the impact and what it means, what can an employer do? So keep in mind there's no impact if someone is not working more than 40 hours in a work week. Those folks are safe, no further action. But for those that are, some options, and John hinted at some of these strategies earlier. You could certainly raise their salaries to keep that exempt status. Just a caution there, because if you do, you have to consider what everyone else is making within that within those positions that are either close to that particular job or a step or two above. Salary compression is when you've got a gap that closes between your less experienced employees and then your more experienced groups.
Yeah, and I think the more pay option makes a lot of sense when you have an employee who is close to that threshold of 47,000 and change, and you're in a situation where you need to spend a little bit more to save a whole lot more. Because if you have an employee who's paid $44,000 a year and you know they work consistently 50 hours a week, it's almost a no-brainer to just bump them up to the $47,000 threshold and be done with it. Now, if you have an employee who is paid $35,000 a year and works 35 hours a week, then we're back up to somebody who's working no more than 40 hours a week. So you don't have to change that person one way or the other. But it really starts with taking an audit and an inventory of your employees who are making $47,000 and less, who are also classified as an exempt, seeing how many hours on average they work every week, and just crunching the numbers and finding out what is going to make the most sense, economically speaking, in terms of paying them. And as you see the bullet points there towards the bottom, it may be that person is going to be kept in an exempt or a non-exempt status, and there's going to have to be more management training on monitoring the hours that are worked, making sure that employees are not working an excessive amount of overtime, making sure that things are done during normal working hours. And as we tiptoe into those waters, I would just like to note I've reviewed more handbooks than I care to admit that have said unauthorized overtime will not be paid. That's a big no-no. All overtime is paid. Unauthorized overtime can be subject to discipline up to and including termination, but you still better pay it. So when we say monitor schedules and control overtime, we don't mean, browbeat these employees and don't pay them or tell them to start working off the clock or off the books. Just get a better sense and control on when individuals are working and how you can control that.
Right. I mean, it would be safe to say that if an employee expects that they're going to be incurring overtime for that week, it would make sense to encourage communication between the employee and the supervisor as a way to kind of say, hey, this is coming, I anticipate, I'm going to be over my 40 hours, and essentially ask permission if that can be done.
Absolutely, and really in that situation, what a manager might be able to do is they could say, well, we have Bob over here and his workload's a little light, so maybe we can have him help you with that, and then nobody works overtime, and everybody is kind of chiming in.
Right, so, okay. This always comes up. Can we just pay comp time, John?
No, goodness no, goodness no. Unless you are a public employer, the words comp time should never leave your mouth. And if you are a public employer and you have that comp time, it has to be based on a prior agreement. It has to be paid at the rate that they're currently earning. There's an upper limit. There is a whole regimented structure that needs to be in place if you want to start going down the comp time path. This is not something that you just dive into willy-nilly. It needs to be a set program and a set plan. That being said, exempt employees have no requirements or obligations under the FLSA whatsoever, and I hear a lot of employers and employees who are exempt use that term comp time. Well, I was here early, I get to leave early on Friday or something like that. That's my comp time. No, you're an exempt salaried employee. You get paid regardless. That's not really comp time. What I hear being referred to as comp time sometimes can be more accurately referred to as flex time. And that's more of a schedule flexibility, where if you have a non-exempt employee who has to come in early on a Wednesday for a particular project that they're working on, and you can say, you know what, you work 2 extra hours on Wednesday, you can leave at 3 o'clock on Friday. That's not comp time. That's just flex time. That's making sure that they're working the required hours in a week. That's something that's a little bit more flexible. That's not really considered comp time. That's just making sure that their schedule is flexible.
Right. That just goes back to communicating with the supervisor about what's on the workload for that week. So just some special things to point out to nonprofits and religious organizations. I think it goes back to looking at that ministerial exemption. You really need to look at the employee's duties. I think job titles can be misleading. So I don't know. John is shaking his head here.
Or I'm nodding. Yeah, no.
Nodding, I should say.
So it's the job. It's the job description itself. It's not the fact that this person is called a manager. It's looking at specifically what do they manage. If they're called a manager and they manage a project, likely they're not going to meet that executive exemption because they're not managing people. So just because somebody is called a manager is not the cure-all for saying that person is going to be exempt. You have to look at the job descriptions themselves.
Right. And going back to teachers, if there is a preschool or a daycare center at a church, for example, those teachers are exempt.
Correct, but I don't want anybody to fall under the misapprehension that there is a distinction between preschool and daycare and instruction and just caring for the physical well-being of a child. And so daycare employees who are not charged primarily with instructing students or younger children would not meet that exemption requirement. It's more of a, you are there for the protection and
babysitting?
Babysitting essentially of the child.
Thank you. Just a couple points here. So as far as volunteering, I've had this question come up already where folks have said, can folks just say, hey, I'm volunteering my time?
Yeah, they can. Here's the thing. They can say that, and as an employer, you can say sure, and then that employee is going to come back around a week later and say, I didn't really volunteer for that. You owe me that. You owe me money for that. So no, never allow an employee who is on your payroll to volunteer their time for anything. Okay. There's no such thing as volunteer time for an employee.
Okay. And averaging hours, just the last bullet point there, as far as you mentioned this before, John, but just to kind of underscore it, that you need to look at your fixed work week, which would be 7 consecutive days.
Correct. Yeah, you can't. There is and I'm not even going to get into it. Right. There's a particular formulation, but it does not apply to 99% of the people out there. You're looking at 7 days. You can't combine.
So, against all these rules and issues to consider, you can't help but think about the impact to the employees and what this means to them. And I think for a lot of folks, if they're not used to tracking their hours and now they're being asked to, that's seen as change. It could be maybe even seen as perhaps a demotion or a step back for some folks who are, proud of their exempt status or their salaried status. Perhaps even less flexibility.
And I think one of the biggest fallouts of this, again, we're talking about unintended consequences, ripple effects, is going to be employee morale. Is going to be situations where you have an employee who they are salaried. They worked however many years they did to build up their professional career, and they felt, you know what, I am now salaried. I don't have somebody looking over my shoulder. I don't have a punch a clock. I can come and go somewhat with a little bit more regularity. And when they are then thrust back into, you're an hourly employee now, that stings. And I was involved in a national collective class action against a larger employer. And as it turned out, a whole group of assistant managers was deemed to be non-exempt when they were previously considered to be exempt. And you would think that all of those employees involved in that class collective action would have been happy.
Sure, additional time, right?
Additional time, more pay.
Right.
They hated it. They hated it. They felt it was a step backwards. They hated the fact that they had to always continually maintain their time. So there is certainly a messaging approach that needs to be considered when we're talking to employees about these types of issues. But as I'll mention in the next slide, there is a silver lining for employers as well.
Okay. So looking at steps that employers can take to get ready for this, again, December 1st is the deadline. Again, I think it starts with taking a step back and looking at those job descriptions, looking at your exempt and your non-exempt duties, figuring out which employees are affected by this. To John's point earlier, looking at the budget, what makes the most sense economically within the organization. Perhaps you're able to bump everyone's pay level to avoid salary compression as an issue, or maybe you just bump those affected individuals, perhaps hiring more employees to spread out the hours, and even downgrading maybe some jobs to take those exempt tasks and push them to other folks. You really need to take a look at how you're going to track those hours. And interestingly, the Department of Labor, I was reading, it seems like they're giving employers a lot of room. It's not like they're saying you need to track all hours. It's just any hours in excess of 40.
Correct.
So it's how, how is your organization going to start now doing that?
Correct. And again, the silver lining that I had referenced previously is, as part of this review of the job description and looking at these employees, if we're all honest with ourselves, even before these regulations are going to take effect, there are some employees who we are all sitting here going, are they exempt? Are they truly exempt? We pay them as though that they're exempt, but we don't really track their hours, and we don't really know if they are non-exempt, we are going to get dinged at some point in time. So the silver lining of these regulations is it provides cover to an employer to go to that employee who's essentially on the bubble one way or the other. We don't know if they're truly exempt, but we treat them as though they're exempt. And you can go to that employee and say, you know what, these new damn regulations, I'm really sorry, we're going to have to reclassify you as a non-exempt employee at this point in time. And it provides you that cover, because anytime you reclassify an employee, it raises red flags in that employee's mind to go, wait a minute. Nothing has changed, yet they just changed my status. That means for the past 2 years they've been underpaying me. Here we go, lawsuit ahoy. This provides an employer with a good cover to as part of this process, to say, you know what, yeah, maybe that person wasn't truly exempt after all, and they're only being paid $26,000 a year, and they work 60 hours a week. Oh goodness, that is a potential, time bomb waiting to explode. We can convert that person without fear of them becoming too suspicious of what we're actually doing. That's the silver lining.
Of course, you want to communicate any status changes or any job duties to anyone that's affected by this. And again, just having anyone who falls, I said below 48,000, but I think it's a good rule of thumb just to keep a record of hours.
Absolutely.
So as far as strategies, couple ways you can look at this. You could communicate with everyone within the company or organization just to minimize confusion, even those folks that aren't affected by this. Obviously, we all know that folks like to chat at the water cooler and such. You could just do specific targeted communication with the affected employees. Again, looking at, is there a status change, any job duties changes, benefit changes to the point about, like, does this now change their life insurance amount, for example, that the company is paying for. But also, looking at, and this, I guess, goes back to just getting a sense as to what those exempt employees are doing. Are they working from home? Do they take work home with them? How do they handle emails, calls after, normal business hours? Do they work through lunch? Are they responding to, emails, text messages, etc.? So I agree with John. I think it is a good opportunity for folks to kind of get a sense as to what exactly the job entails and what the duties are and how much time is being spent in certain places.
Yeah, and Al, I agree with everything Suzanne just said, and the one thing I'm going to add to that is once these lines of communication start come open, once these discussions start to be held, be aware that there are going to be disgruntled employees, and because what we're talking about is compensation, and we're talking about changes to compensation, and we're talking about changes to the way in which these individuals are paid or how these people are reporting the hours that they work. All of these things are terms and conditions of their employment. And whether or not somebody is exempt or non-exempt, that has no bearing on whether or not they are considered to be a management or non-management employee under another federal law called the National Labor Relations Act. And that has, overriding implications in this as well, because what you are going into this fall are conversations about wages with your employees. And if people want to complain about wages, you have to let them, because under the National Labor Relations Act, they have what are referred to as Section 7 rights to engage in protected, concerted activities, discussions with other employees about terms and conditions of their employment. So while you may be, going through some growing pains as it relates to these regulations, you need to know that the discontent or the consternation that these other employees may be showing is something that is allowed and actively encouraged, actually, under the National Labor Relations Act. So to the extent that you have somebody who you feel is, being sour grapes, and you want to come down on them a little bit and saying, don't you talk to that employee about what you're making or what this person is making, you really got to think long and hard before you do something like that, because it could create implications under that National Labor Relations Act as well.
That could be our next webinar.
Yeah, there you go.
So I know we're running over a little bit of time at this point, but just some resources for those of you that may have some questions. And I do see some questions that came through. Tyler, if we have time to, he's shaking his head yes that we can. Just a couple questions that came through. But on this slide, though, as far as the resources, there are lots of fact sheets. Even if you just Google, DOL fact sheet 22, you can get specifics on travel time, on call time. Even folks that are, I don't know, they're a camp counselor and they're, at the summer camp, they're sleeping over. How does that work? So hopefully this will provide you with some further information. And as far as the work week, there are some specific, you'll see this on the slide in excruciating detail there, as far as if you're able to adjust the work week. Employers do have the right to change the work week, but once you decide on whatever day and time you're beginning and ending, you do need to stay consistent with that. So the law is very specific about that, as you can see. So as far as the questions go, a couple questions came in. First one is, do allowances like gym memberships or cell phone count as an incentive? I would say no.
I would agree with you. I would also say no. Those are more fringe benefits and not cash in kind type incentives that would be considered under the law to be those types of
Sure.
benefits.
Okay. And then the other question, in a church, how are the lines between an employee who volunteers to help with an event? Does volunteer time play into the 40 hours per week?
And allow me to revisit that in a minute. When I say you can never volunteer, I want to start with that premise, but so long as this is a situation where maybe as a religious institution or maybe as a nonprofit, there are certain events that an employee is not otherwise required to attend, and they of their own volition say, I would like to go and I'm going to go anyway, I would like to volunteer for something. You gotta tiptoe down those and really treat that carefully. But if that's an employee who is being required to do that or being made to volunteer their time, that's certainly a no-no. But if you have an employee who would otherwise not be required to attend and is not obligated, would not be subject to any type of discipline for not going, and wants to do that out of the goodness of their own heart, I would have a hard time telling that employer to say, to turn that person away. So that being said, it's very dicey. It's a very tricky subject.
Sure. The other question is that came in, could the same job classification have both exempt and non-exempt employees due to tenure?
Absolutely. Yeah, that's an excellent question because, again, job title in the Department of Labor and the Wage and Hour Division is going to tell you time and again, job title does not matter. So just because two employees share the same job title does not mean they need to be treated the same for purposes of exemption status. And you need to meet all three legs of that stool. And if you have one employee who is a longer tenured employee and ergo is making a little bit more and wage into the new salary level, then that person can be exempt. And the other person, because their salary is not to that same level, they'll be non-exempt, even though they share the same title. That's a very good question.
Right, and it makes me think of maybe like entry level. Let's say they're entry level folks within an organization, and maybe some of the folks in that entry level position, they have not advanced, so they are there and they have received maybe, let's say, increases.
Correct.
Right? But that's still their job title. And then if you have someone new that now starts, they're under that $47,000 threshold, then voila, those folks are eligible for overtime.
Correct.
So.
And you have to say voila.
So those are the questions that have come through. I think at this point we're definitely way over. And Tyler's shaking his head yes. I'll turn things back over to him.
Thank you once again for joining us for this presentation produced by McConley and Asbury. We hope you join us for our upcoming events. You can stay up to date with news and learn more about our upcoming events by visiting us at www.macpas.com. Thanks again and have a great day.